Ryan Gass here, PTPGun.com, Firearms Training, and today we're going to be going over DC firearms laws. The capital of the United States of America, the District of Columbia, has been the epicenter of gun control and the subsequent violence that results when disarming the law-abiding population. In recent years, Americans have fought against these infringements in the courts, most notably Dick Heller. Citizens such as Mr. Heller have helped free the district from the depths of the Firearms Control Act of 1975, which banned individual gun ownership. Now, residents and non-residents alike of DC can not only possess firearms, but can also carry a handgun for self-defense with no special reason needed, as still is the case in Maryland. As we move towards the firearms training segment, we have to provide the common disclaimer. Firearms laws are subject to frequent change, and the following summary is not to be considered legal advice or a restatement of the law. To determine the applicability of these laws to specific situations which you may encounter, you are strongly encouraged and urged to consult a DC-based attorney. What is the purpose here? What are we trying to do? This is to help those who are wanting to meet the training requirements to apply for their DC concealed carry license. PTP does not apply for your license for you, nor can we register your firearm as well. This is the responsibility of the individual applicant. Some of the main topics we're going to cover today include where to find and read applicable laws, disqualifying factors, restrictions on carry, how to transport your firearm. We're also going to go over DC case law and self-defense, as well as how to interact with law enforcement, and where to find legal counsel. Now, as always, I always encourage people, whether it's a video here on YouTube, whether it's out at a class, whether it's anywhere, if anyone provides you with any information, especially when it comes to law, you want to read and verify exactly what the law says. Don't go based off what somebody else told you, because far too often do I find people spreading misinformation that was told to them by somebody else who had misinformation told to them by somebody else who had told that to them. So break that chain and go over what the laws actually say. Even though I'm telling you what the laws are and I'm showing you where they say, I want you and I'm encouraging you to go out there and independently verify all of this information being given to you. So what is reciprocity? Reciprocity is when two states get together and they have a written reciprocity agreement that more or less says, I'll recognize your permit if you recognize ours, all right? Now, DC doesn't have a reciprocity agreement with anybody. They do not have reciprocity with any other states. But there are other states that recognize the DC carry permit. Now let's talk about that. Now, recognition. Now, recognition is if a state decides on their own that they are going to recognize the training or the licensing of an individual from another jurisdiction. That does not require DC's participation in that recognition. Whether DC likes it or not, states such as Virginia recognize the DC carry permit, and in Virginia and states that recognize DC, you can carry simply having that DC carry permit, even if you don't live in Virginia or even if you don't live in DC. So, no state has a reciprocal agreement with DC, but again, we've talked about there are states that recognize the DC carry license. Let's take a look and see what those are. So as you see here, we have a map showing you what states recognize DC and which ones don't. Those, as shown here, those in green and orange recognize the DC carry permit. You can carry in those states. Now, those in orange have special rules pertaining to that, so you have to look into those states' special rules if and when you travel to those places and you're wanting to carry with your DC license. But again, those in green and or orange, you are good to carry in DC. Now, again, that is as of today, which is the middle of February 2022. If you are watching this in March or April or in 2023, 2024, this may have changed. That list of states that recognize DC, it may have expanded. It may have come down to a smaller amount of number, but you want to make sure you independently verify that before you go about traveling to other states. So the map that we're looking at here, that is for those who are not residents of DC that have their DC carry license. If you are a resident of DC with your carry license, you actually get 2 additional states. And let's take a look at that map. So the map, as we're looking at it here, this is pertaining to non-residents with their DC carry license. Now, the DC non-residents with a DC carry license, you're good in 26 different states. If you are a resident of DC and you have your carry license through DC, you get 28. So let's take a look at that. So here, non-resident, now we move into resident. So residents, they get 28 states. Again, green and orange. The difference between resident and non-resident, residents get also Vermont as well as Michigan. So how do I go about seeing where my permits are good at and where they're not good at? Where did I get these maps from that I'm showing you? Well, I have an app on my phone, and here we can see it is CCW Concealed Carry 50 State. It's $1.99. I bought it on my Android phones. I'm pretty certain that iPhones have this app available as well. And it's a great app. You can put in there, it has a list of all the different permits you can get, both resident and non-resident. And I can put in my permits that I have, and I can see where they're valid at. So if I'm gonna go out and travel abroad, I'm gonna go down to Texas, or I'm gonna go do a road trip out to Idaho. I can see where my permit is good at and where it's not, based on where I'm gonna be traveling to. Now, I don't travel much, so I don't check on this too often, but a lot of people that I know, they travel a lot. They do a lot of road trips. Maybe they're a truck driver, and they need to know on the daily where their permits are good at and where they're not, and this is a great application for that. So as I said before, I highly encourage that anyone that participates in any type of training and or watches any video on YouTube, including but not limited to this one, that you go and you independently verify what does the law actually state. And when you're looking in the DC code and you're trying to verify what the DC code actually says, Chapter 25 relates to firearms control, and Chapter 45 relates to weapons and possession of weapons. And there's a lot of good information in there. Obviously, a lot of it's being presented in this video, but you should definitely go out there and independently verify and see exactly what the law states. Just because it's on the internet doesn't make it true. Just because I put it in my YouTube video doesn't make it true. Although everything that I'm presenting in this video is accurate and true to the best of my knowledge at this time of filming. Now, all firearms in DC, whether they're going to be strictly in your home or your business, or if you're going to be carrying them, they must be registered. In order to register a firearm, you have to meet some certain requirements. You must be 21 years of age or older, not convicted of a weapons offense or a felony in any jurisdiction, not under indictment for a crime of violence or a weapons offense. Now let's take a look, because we've seen that phrase pop up twice, weapons offense. What exactly is a weapons offense? Let's look at how DC defines this. A weapons offense is any violation in any jurisdiction of any law which involves a sale, purchase, transfer, in any manner, receipt, acquisition, possession, or having under control, use, repair, manufacture, carrying, or transportation of any firearm, ammunition, or destructive device. You cannot be convicted within the past 5 years for a narcotics or dangerous drug offense, threat to do bodily harm, or for assault. Not acquitted of any criminal charge by reason of insanity, or adjudicated a chronic alcoholic by any court within the past 5 years. Not voluntarily or involuntarily committed to any mental hospital or institution within the past 5 years. Cannot suffer from any physical defect that would make it unsafe to possess or use a firearm safely and responsibly. Not found negligent in any firearm-related mishap causing death or injury to another person. Not convicted of a misdemeanor intrafamily offense, domestic violence. Not dishonoring discharge from the U.S. Armed Forces. Not a citizen of the United States who's renounced his or her citizenship. Not legally blind. Within the past 5 years, you cannot have been convicted of 2 more violations for driving under the influence. Not the subject of a civil protection order. Not convicted of stalking. Not convicted of negligent storage of a firearm or a violation of the Firearm Registration Act. Not had a history of violent behavior. And residents must complete additional training with the Metropolitan Police Department free of charge. Now, your registration application for any particular firearm must be delivered by yourself in person, and you must set an appointment with the MPD in order to do so. We will have a blog article with a link in the description below, and that blog article will have explicit directions on how to go about doing that. Now, just because you have a firearm registered by itself doesn't mean that you can carry that firearm. Much like driving a vehicle, you must have that vehicle registered and also have a driver's license. So just because you have a firearm registered, and that by itself doesn't mean you can carry. You have to have that as well as your concealed carry license. Now, as of November of 2021, the DC Metropolitan Police Department no longer issue physical cards that are registration certificates for a firearm. Now they email you a digital registration, which you're expected to have on your person. Now you can have it in that digital format on your phone or a tablet or a laptop, or you can have it in a physical version. You can print it off. I recommend that you have both. I recommend that you print it off and have multiple copies of that. Have it in every glove box of your vehicle. Put a copy in your wallet. Put a copy in your purse. Put a copy in your laptop bag. Have it in your laptop. Have it in your phone. Have access via your email. You want to make sure that if you are dealing with law enforcement and you have your firearm on you, that you have some way, shape, or form to be able to prove that that firearm is registered to you. Now, in regards to the concealed carry license itself and or the registration, you have some basic duties you have to comply with. Now, it's basic common sense a lot of times. If anything changes, if your name changes, like ladies, if you get married, people, if you buy a new house and you move, hey, let them know. Not a big deal, but you need to let them know and they can update you in their system. With it comes to the firearm registration. If you sell that firearm or you lost it or maybe it was burnt up in a house fire, update them, let them know about that. It's not a big deal. Life happens, things change, but you have to let them know. Now, if you're found to be in violation of any of these duties, first time is still a fine of $100. Second time is still a fine of $500, and they can revoke your registration for that firearm as well as temporarily disqualify you from registering a firearm during that time. The third time is the same as the second, except for they can permanently disqualify you from ever registering a firearm again with DC. So outside of a carry license, if you have a valid registration for a firearm, you can carry it during certain times, including while in your home, for a lawful recreational purpose, while in your business, and or while it's being transported for lawful purpose as expressly authorized by statute in accordance with the transportation requirements. Now, when you go to apply for your DC concealed carry license, there'll be a $75 application fee and a $35 fingerprint fee collected by the DC Metropolitan Police Department. This can be made via cash or card. They'll also need to see 2 documents establishing where your residence is. It doesn't matter if it's in DC or not. You can be a non-resident. They'll also need to see your training documentation, which we will provide to you electronically upon successful completion of the entire training course with us. And then also, if you're applying for your concealed carry license and you're going to register your first handgun at that time, the $13 application fee for that registration is waived. Now, your application is going to have certain requirements, including having completed the firearms training course or combination of courses conducted by an instructor certified by the chief who includes at least 16 hours of training and covers the following: firearm safety, firearm nomenclature, basic principles of marksmanship, care, cleaning, maintenance, loading, unloading, and storage of pistols, situational awareness and conflict management, as well as use of deadly force, selection of pistols and ammunition for defensive purposes, all applicable district and federal firearms laws, including the requirements of this unit, Chapter 45, Title 22, and district law pertaining to self-defense. Also, you have to complete 2 hours of range training conducted by an instructor certified by the chief, including shooting qualification course of 50 rounds of ammunition from a maximum distance of 15 yards. Also have to comply with any procedures that the chief may establish by rule. As a concealed carry licensee, you'll have certain duties you have to comply with. You have to disclose to an officer that you are carrying a concealed pistol, present the license and registration certificate when requested, identify the location of the concealed pistol, and can comply with all lawful orders and directions from the officer, including allowing a pat-down of his or her person or permitting the law enforcement officer to take possession of the pistol for so long as necessary for the safety of the officer or public. Now, I want to go ahead and start off by saying, I'm not saying that this is constitutional, I'm not saying that this is legal, that they can do this without probable cause, without a warrant. I'm just telling you what the rules and duties set forth by DC are. Now, let's go ahead and break down part of that last duty that we saw there. It said permitting law enforcement officer to take possession of a pistol. That might be a rule of theirs, but that doesn't mean that you have to hand it to them. There's no need for you to handle a firearm at any point in time in the presence of law enforcement. While they might ask to take possession of that firearm, that doesn't mean that you need to give that possession to them. That means that you can allow them to take possession of it. What I would do, instead of an officer asking me to have my firearm and I hand my firearm to them, instead I might say, okay, let me, if you like, I can step out of the vehicle, put my hands on the vehicle, you can take the firearm off of my person, but I'm not going to handle this firearm. I'm not going to hand the firearm to you, but I'll allow you to take it off of me. Why is that? It's not that law enforcement are out to get you. It's not that they're bad people. It's that you can't control what you can't control. While you might be talking to this officer at your driver's side door about everything, and they're dealing with you, and they're saying, "Oh, go ahead and hand me that firearm for the safety of you and I for the duration of the stop," I would not hand it to them because you don't know who's on the other side. While I'm talking to him, he may have a partner or a junior officer that he's training up, he or she is training up, and they don't hear the main officer interact with me. They don't hear them say, "All right, go ahead and hand me that firearm." All they see is you pull that firearm out of your holster and start bringing it towards that officer's direction. And that's how you get shot, ladies and gentlemen. That's how you get shot. So I would not recommend that you ever handle your firearm at any point in time. It doesn't matter if you know this officer or not. It doesn't matter how cool you are with them or not. You don't know what you don't know. Does that make sense? So let's now discuss lawful transportation of a firearm. A person not otherwise prohibited shall be permitted to transport a firearm from any place where he may lawfully possess and carry a firearm to any other place where he may lawfully possess and carry, if the firearm is transported in accordance with this section. Transportation by vehicle. It needs to be unloaded, firearm and ammunition not readily available, and not directly accessible from the passenger compartment. So generally speaking, you want to have them as separated as possible. So I would say ammunition in the passenger floorboard, firearm all the way as far back in the rear of the vehicle as possible. Let's say you happen to be on a motorcycle. Say you have saddlebags. Put a firearm in one side, ammunition in the other. If you happen to not have saddlebags and you've got a backpack, just make sure that the gun is locked up in a case, perhaps, and the ammunition is in a separate part of that backpack. Does that make sense? Again, as I just kind of went over, if no separate compartment, unloaded firearm and ammunition shall be contained in a locked container other than the glove compartment or console, the firearm shall be unloaded. And C, transportation in any manner other than in a vehicle, firearm needs to be unloaded inside a locked container and separate from any ammunition. So as we get further into law, we're going to be having legal definitions coming up of how the District of Columbia defines certain words, because we need to know how certain words are defined in order to better understand what the law actually means. So let's go ahead and touch on one of those now. First definition we're going to go over today is public place. A public place is a place which the general public has access and a right to occupy for business, entertainment, or other lawful purpose. Now, even with a concealed carry license and a registered handgun, there are still certain times and or places in which you cannot carry. Let's take a look at those now. 1. You shall not carry a pistol while consuming alcohol or while impaired. 2. A building or office occupied by District of Columbia or its agencies. 3. The public grounds, including the adjacent parking lot of a child care facility, preschool, elementary school, secondary school, or a public or private college or university. 4. A hospital or office where medical or mental health services are the primary services provided. 5. A penal institution, secure juvenile residential facility, or a halfway house. 6. A polling place while voting is occurring. 7. A public transportation vehicle, including the Metro Rail transit system and its stations. A public transportation vehicle is any publicly owned or operated commercial vehicle, including any DC circulator bus, DC streetcar, Metro access vehicle, Metro bus, or Metro rail train. Any premises where alcohol is served, sold, and consumed on the premises. 9. A stadium or arena. 10. Public gathering or special event open to the public when the organizer has provided notice and posted signage prohibiting the carrying of concealed pistols in advance of the gathering or special event. 11. The public memorials on the National Mall and along the tidal basin, and any area where firearms are prohibited under federal law or by a federal agency, including the U.S. Capitol buildings and grounds. The area around the White House, between Constitution Avenue, 8th Street, and between 15th Street and 17th Street Northwest. 13. The U.S. Naval Observatory and its grounds, from the perimeter of its fence to the curb of the Massachusetts Avenue Northwest, from 34th Street South on Massachusetts Avenue to Observatory Circle Northwest. 14. When a dignitary or high-ranking official of the United States or a state, local, foreign government is moving under protection of MPD, U.S. Secret Service, U.S. Capitol Police, or other law enforcement agency that does not include a distance greater than 1,000 feet from the moving dignitary, provided that notice was given by signs or an officer's orders. 15. A demonstration in a public place within a perimeter of 1,000 feet designated by a law enforcement agency and the notice was given by signs or an officer's orders. How do we define demonstration? D.C. defines demonstration as one or more persons demonstrating, picketing, speech-making, marching, holding a vigil, or engaging in any other similar conduct that involves a communication or expression of views or grievances and has the effect, intent, or propensity to attract a crowd or onlookers. The term demonstration does not include the casual use of property by visitors or tourists that doesn't have the effect, intent, or propensity to attract a crowd or onlookers. Number 16. On private residential property, unless authorized by the property owner, non-residential property that is posted with conspicuous signage prohibiting carrying of a concealed pistol. Again, residence is a building wholly or partly used or intended to be used for living or sleeping by human occupants, together with any fences, walls, sheds, garages, or any accessory buildings appertant to the building, and the area around the surrounding building, and actually or by legal construction forming one enclosure in which such a building is located, but does not include adjacent common areas or commercial property contained in any part of the building. Now, exceptions. While driving a vehicle into or immediately parking at any location listed in subsection A2 of this section for the purpose of picking up or dropping off a child or student, provided that the licensee shall secure the concealed pistol in accordance with subsection 22-4504.02b before leaving the parked vehicle. Now let's talk about storage of firearms. No person shall store or keep any firearm on any premises under his control if he knows or reasonably should know that a minor is likely to gain access to the firearm without permission of the parent or guardian of that minor, unless such person keeps the firearm in a securely locked box, secure container, or other location which a reasonable person would believe it to be secure. 2. Carries the firearms on his person or within such close proximity that he can readily retrieve and use it as if they carried it on their person. Now, if you violate this section and a minor causes injury or death to himself or another, you shall not be fined more than $5,000, imprisoned no more than 5 years, or both. Now, this doesn't apply if the minor obtains the firearm as a result of an unlawful entry or burglary to any premises by any person. Now, for the purpose of this section, a minor shall be a person that is under the age of 18. Now let's get into ammunition. No person shall possess ammunition in the District of Columbia unless they are a licensed dealer, an officer, agent, or employee of the District of Columbia or the United States of America on duty and act within the scope of their duties. They hold a valid registration certificate for a firearm that does not include restricted ammunition. The person held an ammunition collector's certificate on September 24th, 1976, or temporarily possesses ammunition while participating in firearms training and safety class conducted by a firearms instructor. Now let's get into ammunition and how they actually define it, because it's actually pretty unique and it's very broad in how they define it. So ammunition is defined as cartridge cases, shells, projectiles including shot, bullets including restricted pistol bullets, propellant powder, or other devices or materials designed or intended for use in a firearm or destructive device. No licensed dealer shall sell or otherwise transfer ammunition unless the sale or transfer is made in person. 2, with valid registration certificate. Now, the non-residents will have to have proof that the weapon was lawfully possessed in the jurisdiction where the person resides. 3, same caliber or gauge as the firearm on the registration certificate. And 4, the purchaser signs a receipt. Dealers maintain all records for at least 1 year. Now let's talk about the ammunition carried by a concealed carry licensee. Now you cannot carry no more ammunition than is required to fully load the pistol twice, and in no event shall that amount be greater than 20 rounds of ammunition. Now let's go ahead and talk about that, because that should be playing a part into deciding which firearm you're going to register and carry in DC. Personal opinion, you should carry as much ammunition as legally possible. And with this, that number is 20. So that's gonna be a dilemma if you have a smaller gun with a lower capacity than the average gun. You should want to find a firearm that has a magazine capacity of 10 rounds. And I'll explain to you why. If you have a standard capacity Glock 43 standard capacity is 6 in the magazine plus 1 in the chamber. So if we have 1 in the chamber plus 6 in the magazine, that puts us at 7. So that means that we have a maximum now of 13 rounds that we can carry with the standard Glock 43 standard magazines. Now, if we have a pistol like a Glock 17 and we buy magazines that are limited in capacity, because standard capacity is actually 17. So to be in compliance with DC law, which we're going to talk about in a moment, you have to have magazines that are 10 rounds or less. So again, say I have 10 round magazines. I have 10 plus 1, that puts me at 11. That means that second magazine, I can put 9 in that. And that is our best case scenario. Because again, we want to get as close to that 20 rounds as possible. So as I just alluded to just a moment ago, high capacity magazines in DC, there is a lot of rules regarding that. So let's go ahead and talk about that and see exactly what the law states. No person in the district shall possess, sell, transfer any large capacity ammunition feeding device, regardless of whether the device is attached to a firearm. Large capacity ammunition feeding device means a magazine, belt, drum, feed strip, or similar device that has a capacity of, or that can be readily restored or converted to accept more than 10 rounds of ammunition. Now, let's talk about that, because a lot of people that follow our channel here, a lot of people that have been to our classes, they are familiar with Maryland and the fact that Maryland, you can possess those magazines, you can use them, you can carry with them, you can do a lot with those magazines. Again, you just cannot sell, buy, transfer the magazines. But in DC, you cannot even possess them. All right. And another big thing I saw that really touched me is the fact that I know that a lot of people in Maryland, they'll buy handguns, and they will come with magazines that are capacity of more than 10 rounds, but that they have been modified or plugged so they can only accept 10 rounds or less. Per DC law, the way that it's written, it says clearly, or that can be readily restored or converted to accept more than 10 rounds of ammunition. So if you have a plugged magazine in DC, you get caught with that, that can be a charge as well. Now there is one exception, all right? The one exception is the term large capacity ammunition feeding device shall not include an attached tubular device assigned to accept or capable of operating with 22 caliber rimfire ammunition. So like my little Henry lever action, if it can hold 11 rounds or more, that will not be against DC law. Now let's talk about transfers a little bit. No person or organization shall sell, transfer, or otherwise dispose of a firearm or destructive device or ammunition in the district. Only dealers can. Any person or organization eligible to register a firearm may sell or otherwise transfer ammunition or any firearm, except those which are unregisterable under subsection 7. Now, if you buy or transfer a handgun in DC, there will be a 10-day waiting period, which doesn't apply to law enforcement. Now, whether a handgun or a rifle or a shotgun, these all can be registered in DC. But there are items that have been banned or prohibited from registration in DC. And those include sawed-off shotguns, machine guns, short-barreled rifles, or 50 BMG rifles. These items are otherwise legal, and you can buy them in other states and have them in other states federally, but DC says it doesn't matter what the ATF says, it doesn't matter what kind of clean background you have, it does not matter to them. They blanketly said, nope, we cannot allow you to own, possess, register these firearms in DC. So now let's take a look at some of the dumb things, additional dumb things that have been done by DC legislators. So before we get into it a little bit, assault weapon is a political term. It's a term that is defined by politicians and legislators in every jurisdiction. It changes whichever way the wind blows and whichever jurisdiction you're in at that time. But how DC has defined an assault weapon is a semi-automatic pistol with a detachable magazine and any one of the following. Let's see what those things are. A threaded barrel capable of accepting a flash suppressor, forward hand grip, or a silencer. A second hand grip, which a pistol with a second hand grip doesn't exist, and we'll talk about that here in a moment. A shroud that's attached to or partly or completely encircles the barrel that allows the bearer to fire the weapon without burning his or her hand, except a slide which encloses the barrel. Now let's talk about that second one. Per federal law, a semi-automatic pistol with a second hand grip is no longer a semi-automatic pistol. It is now any other weapon, or an AOW. So per DC law, there is no such thing as a semi-automatic pistol with a second hand grip. It doesn't exist, legally speaking. Thank you, ATF.
Good job. Good job. Really good job.
Now let's talk about that last one. A shroud that is attached to or partly or completely encircles the barrel or allows the bearer to fire the weapon without burning his or her hand. They literally put themselves out there to look like idiots. Right? So, for example, AR-15 pistol, it has a barrel shroud or handguard that protects your hand from burning, because if you fire that weapon 3, 4, 5 times, it quickly gets heated. It quickly gets to the point where it can burn your hand if you touch it. So the barrel shroud or the handguard helps protect your hand from that heat. And they explicitly put that in the law. They explicitly acknowledge that it's there to keep you from burning your hand. So if you have that on your AR-15 pistol, that makes it an assault weapon. But if you take it off and you burn the hell out of your hand, don't worry, you're safe now. That's no longer an assault weapon. Thank your DC politicians. This, I can't make it up. I can't make it up. Now, DC has their own list of approved firearms that they say are safe and whatnot. But additionally, a pistol that is on the California register and or on the Maryland or the Massachusetts list, those are approved as well. In 1968, the United States federal government passed legislation requiring that all commercially developed firearms are now required to have serial numbers. Now, firearm manufacturers prior to that started doing serial numbers prior to that for decades, but after 1968, they're now required. If you have a commercially developed firearm and they have a serial number on there, you cannot mess with that serial number at all. You cannot obscure the view of it, you cannot paint over it, Dremel it off, nothing of the sort. It is unlawful to alter or obliterate any manufacturer identification mark or number on any firearm. Any person in possession of such a firearm is presumed to have committed the offense. This includes microstamps. What are microstamps? Beginning January 1st, 2018, a semi-automatic pistol shall be microstamp ready if it is manufactured in District of Columbia, manufactured after January 1st, 2018, and delivered or caused to be delivered by any manufacturer to a firearms dealer in the District of Columbia, or manufactured on or after January 1st, 2018, and sold or offered for sale, loaned, given, or transferred by a firearms dealer in the District of Columbia. What exactly is microstamping though? Let's take a look and show you. So as you see here, what you're looking at is actually the face of a firing pin. It has a unique code imprinted on that. And what's happening is when that firing pin comes down, it strikes the primer, it leaves that unique mark on that casing. And now whenever that casing is extracted and ejected out of that firearm, and the idea is that when law enforcement show up to the scene of a crime and they go out and they find these casings, they can look at the code and they can put it in their system and they can track that casing back to your gun, back to you, solving the crime, saving the day. Now, I'm open to the idea that I do not know everything and that I don't catch everything and that there's things that make it past me. But I've yet to see where this technology has ever solved a firearms-related crime in DC. This has costed taxpayers millions to put this program together and sustain it over the years. This idea, this technology, it was a pretty cool idea, pretty innovative. But it's been proven with years and years and millions of dollars to not be practical, to not be beneficial to District of Columbia, its residents, its visitors, or the taxpayers. So we are going to now move on to District of Columbia, and we're going to talk about case law. This is set by judicial precedent rather than statutes. Now we're going to have to discuss more definitions, one of them being very important, deadly force. How does DC define that exactly? DC defines deadly force as the force that is likely to cause death or serious bodily harm. Well, how do we define serious bodily injury? They define serious bodily injury as injury that requires hospitalization or immediate medical treatment in order to preserve health or well-being of the individual, preventing long-term physical damage, potentially permanent injuries, abating severe pain. Now, what does not help constitute serious bodily injury? Ice packs, bandages, self-administered over-the-counter medications, they don't count, even if administered by a medical professional. Now, jurors can consider the nature of the alleged injury itself and the practical need for ordinary course of events for hospitalization or prompt medical treatment in determining whether the significant bodily injury actually occurred. The injured person does not have a duty to be seen by a medical provider. Now, let's get into self-defense. You are entitled to the claim of self-defense, including deadly force. 1, if you actually believe that you're in imminent danger of bodily harm, and 2, if you have reasonable grounds for that belief at the time of the incident. Regardless of all that, though, you cannot be excessive. Now, that is determined by the situation itself. A person acting in the heat of passion does not necessarily lose the claim of self-defense by using greater force than would seem necessary to a calm mind. In the heat of passion, a person may actually and reasonably believe that something seems unreasonable to a calm mind. That's because we have to consider it in the context of that situation at that moment, but what you saw, heard, felt, that is all going to play a part into whether what you did was reasonable or excessive. Deadly force may be used even if the defender was not in actual danger. The perception must, though, be reasonable in the moment. Now, that might be confusing for some. Let's take a look at actually what that might look like. Let's take a look at some clips here. Now, in this first video, we see a group of individuals walking down these stairs, and they're coming down, and you see that clown in the background. And there's a fake body there, and he smashes that head of the fake body and starts running towards those individuals as if he's going to do that same bodily harm to those individuals. It's reasonable to believe that that clown, if they get in close proximity, could create that same deadly force to those individuals. So it'd be reasonable for them to defend themselves in that type of situation. It has a false appearance, but the perception is their reality. Now let's take a look at this next video. They got the individual with the mask on, and these 2 other individuals are sleeping on this bed, and he starts up this chainsaw. And I don't know whether there's a chain on the chainsaw or not, but the perception is that that guy's a random serial killer coming in there to do serious bodily harm to them using that chainsaw. Generally, a person may not use deadly force to protect his or her property. However, a person may use deadly force to protect his or her home or business if he or she has reasonable belief that an intruder is entering his or her home or business with an intent to commit a felony or to do serious bodily harm to any of the occupants. Note that in case law in the district does not explicitly extend to businesses the principle of defense of property, but appears to have recognized it implicitly. Other jurisdictions recognize defense of the home and recognize defense of the business. Now, again, getting more into the actual defense of property, again, how this is worded and stuff, it's kind of confusing. It kind of is really deep on topic, the way that DC does it. But long story short, you can't defend property using deadly force. You can defend yourself or your those around you, whether in your home, whether at your business. You can defend those people against bodily harm, against serious bodily harm, against death, but you cannot defend the property itself. I cannot defend my laptop, my vehicle, my TV and whatnot, all right? You cannot defend the property using deadly force, but you can defend people, all right? Let me break it down like this, all right? Give you a little scenario, all right? You go to an aquarium and stuff, and you have your kids, and you guys are having a great time. You're seeing all the different fish and the displays and all that stuff. And now you guys are at the shark exhibit, and you guys are on a platform, and it's overlooking the shark tank. You guys are taking pictures and again, enjoying your time. But you drop your phone. You take a picture and stuff, you drop your phone into the shark tank, down in the shark tank. or your wallet or something, your keys, something like that valuable falls into that shark tank. Are you going to jump in that shark tank after that item and retrieve it to defend that item from the sharks? No, you're not. No, you're not. You're not even going to think about it. You're not even going to hesitate and try to think about jumping over that railing. All right? But a little bit different. If your kid's, looking down in the shark tank and they fall over the railing, they fall down into the tank. All right? What are you going to do? All right? You have to ask yourself, which kid is it? No, but seriously though, with your kid, you're not even going to think about it. You're not even going to hesitate. You're going to be jumping right over that railing after them. You're going to be falling in that tank. You're going to be swimming around, getting that kid, throwing them out of there, and doing so even at risk of yourself. There's a good chance that if you do that you may experience death or serious bodily harm. That shark may bite, may hurt, may kill you, right? But even with that in your mind, you're not even going to think about it. You're not going to hesitate. You're going to jump in there and you're going to defend your kid and get them out of there. That's the difference. And that's what you got to think about. That's what you got to consider. Is it worth risking your life and safety over? Is it? Because if it's not, then you shouldn't be using deadly force to defend it. So the general rule is that you only use deadly force in extreme necessity, only as a last resort, when all lesser means have failed or couldn't have been reasonably employed in the first place. Let's break it down to 4 rules, all right? And these 4 rules must be present and they must remain present. You have actual fear of death or serious bodily harm for yourself or for another. It doesn't matter who it is. It doesn't matter if you know them, whether it's your child, whether it's a family member, whether it's a friend or coworker, or just some random person. All right, you're in actual fear of death or serious bodily harm for yourself or another. You are the innocent party. You're not the aggressor. Lesser force would not suffice, and escape not being possible. Actual fear of death or serious bodily harm. All right. It has to pass the reasonable person test. All right, does the attacker have immediate means and opportunity to present that force to you? All right, there could be a physical disparity of force, and that could apply as well. And what I mean by that is, again, older, frail great-grandmother in their late 90s, that is going to be a disparity of force compared to, let's say, even a 50-year-old Mike Tyson. Right? Those two in a fist fight, there is a huge, referred to as disparity of force between the two individuals. That is going to play a part as well. Now, the attacker does not have to have a weapon. A person can pose death or serious bodily harm to another person without any type of weapons, whether traditional weapons or weapons of opportunity, whether it's a gun or a knife, or whether it is a folding chair, a bat, a hammer, anything like that, a weapon of opportunity. And distance may not matter depending on the situation. Like if a firearm, there's going to be, if a firearm is present and stuff, the distance doesn't exactly matter, right? Now, if somebody's got a knife and they're 100 yards away, all right, that's going to be obviously a lot less of immediate threat to your bodily safety than somebody with a gun 100 yards away, right? Now, it might be, depending on the weapon system and the person, it might be less likely to hit you at 100 yards away. But 100 yards away, a gun-wielding attacker, 100 yards away, a knife-wielding attacker. There is a difference there. Now, rule number 2, let's get more into that of you are the innocent party. You cannot be seen as the aggressor. And just because they were the aggressor doesn't give you grounds to escalate the situation. It doesn't matter who started it, you must try to de-escalate and try to get out of there. All right. Also, this is a very real thing, and a lot of people don't really understand this or have never maybe heard this, but the prosecutor can go back in your past and try to find things and use that against you, including but not limited to social media posts. Oh, if that person were to do this, I would have shot them on the spot. If somebody breaks into my home, I'm not asking questions. I'm shooting first, asking questions later. That is such an ignorant statement that will get your ass hemmed up hard. All right. Also, another thing that I see a lot of people do is they will say, they'll post a sign that says, trespassers will be shot, survivors will be shot again. If you don't believe that's going to be used against you in a court of law, whether civilly or criminally, you are dead ass wrong. So the 4th rule again is that your escape from the situation is not safely possible. It could be because that the person has control over you. Your aggressor has control of you. They've got you pinned down. They're on top of you. Maybe they have a firearm and you cannot safely get a situation because they will shoot you as you're leaving that situation. Maybe there's physical dangers. Maybe again they're blocking the only exit, or maybe you do have an avenue of escape, but escaping in that regards is going to create equal or even more danger to you. So let's say, yeah, I can escape this deadly threat right here. I can run this way, but running that way, there is a cliff right there. There is a couple lanes of traffic that's actively moving. Maybe I could jump this fence and escape the person, but on the other side of that fence is an aggressive dog. All right. If escape is not safely possible, then you do not have to try to escape. So let's go over a few scenarios and incorporate what we've learned at this point and decide what we're doing in a situation, whether it's reasonable or not. Scenario 1, you're pulling into your apartment complex and you notice a neighbor standing on his 3rd floor balcony. You exit your vehicle and head toward the front door of your 1st floor apartment. Leaning over his balcony, your neighbor, who has threatened you in the past, pulls a knife from his waistband and shouts, "You're a dead man." Fearing death or great bodily harm, you shoot your neighbor. Let's look at that. Let's talk about it. All right, so again, you pull into your apartment complex, you notice your neighbor standing on his 3rd floor balcony, not the 2nd, not the 1st, 3rd floor balcony. He's on that 3rd floor balcony and he's threatening you with a knife. Is it reasonable to think that that is an immediate threat to your safety? I would say no. Again, because of the space between you, because of the type of situation, again, they have to come down from that 3rd to the 2nd to the floor to get to you to effectively use that knife. All right. Yes, they have threatened you in the past, and yes, it can play a part in what you're talking about. But as presented in this situation, I don't feel that this would be a good situation to be able to use deadly force to defend yourself. All right. Now, this might change depending on things that you might know. Again, if you know that this neighbor on the 3rd floor balcony, if they are very proficient with knives, and let's say that you know that they throw knives professionally and they're very accurate and effective with that, that would maybe change things a little bit, right? But as presented, that information wasn't included in this. So as presented, that wouldn't be a good scenario to be using deadly force. Let's look at another scenario. After entering a restaurant, another individual steps on your toes. You mutter a derogatory term under your breath. The individual bumps you into your shoulder, knocking you back. You shove the individual to the floor. The individual jumps up from the floor and charges at you with a knife. You pull out your concealed handgun and you shoot the knife-wielding attacker. Let's break that one down. First off, you didn't start it per se. Let's say they started it by stepping on your toes. Let's just assume that it was done by purpose. All right? You didn't need to respond with that derogatory term under your breath, all right? That kind of, whether you meant to or not, that escalated the situation, right? But that's not highly unreasonable. That might happen by mistake. So let's move past that. The individual bumps you into your shoulder, knocking you back, all right? That wasn't necessary. They shouldn't have done that. But was it necessary for you to, again, shove that individual to the floor? No. While, again, they escalated it, guess what? You just escalated it as well. You continue that situation as well. You could have left the situation as it's being presented. Now, again, at this point, now the individual jumps on the floor, now they take out a knife, and now they come at you. All right? We got to that point, yes, and that would be by itself a means to be able to use your self to defend against death or serious bodily harm, but we could have avoided it along that way. There's no reason it should have got to that point. We could de-escalate it, we could have escaped the situation and moved on. Let's look at another scenario, all right? You leave a busy city street and you turn down an alley to take a shortcut to your car. You're on foot. An individual approximately half your size steps from behind a dumpster and pulls their shirt aside, reaching for a semi-automatic tucked into their waistband. You shout, "Don't hurt me," and you draw your firearm from your holster, leaving your pepper spray in your pocket. Is that unreasonable? No, I don't think so, because again, they have a firearm, so why would you engage them? Why would you try to defend yourself using pepper spray? That's not an effective tool for that situation. If you're presented with a deadly threat, which a firearm provides a deadly threat, then you can, again, use your firearm. You can skip past those lesser means because they couldn't have been what? Reasonably employed. The individual draws his firearm from their waistband and they elevate it towards you in an effort to shoot you. You, with your firearm already drawn, fire 2 rounds at him. One strikes him in the shoulder. He immediately drops his firearm and it slides underneath the dumpster. So the firearm in that scenario, at that moment at least, is being perceived as being not readily available to them. All right? Bleeding, the individual stumbles towards you. The individual refuses your further verbal commands to stay back, and he steps into what you consider to be your danger zone. So you shoot him again. Now let's talk about that and think about some things. All right? And this is some things that your lawyer is going to be obviously discussing and fighting on your behalf and bringing to light. But in that scenario, based on my experience in training, what I would say is this. All right, the person no longer has their firearm that you saw, is now underneath the dumpster. They're not trying to get it. They're coming now towards you. They're stumbling towards you. You give clear verbal commands to stay back, right? They ignore those, and they're coming at you still. Things that I would think about, and that weren't brought up in this scenario, all right? But why are they coming towards you, all right? You just shot them in defense of yourself, which was reasonable, but they're still coming towards you. Why are they doing that? Are they high on drugs? Do they have another weapon that you have not yet seen, whether it be a knife, whether it be another gun? Why are they continuing to advance towards you even though you've shown your capability and what you're willing to do to defend yourself? You've already done that, right? So things like that are going to play into your perception in that moment, and those are the things that you're going to want to shut up and lawyer up and let your lawyer fight on your behalf regarding and bring those types of elements to light in the courtroom. So let's look at one last scenario to tie it all together. On your way home from work, a dog runs out in front of your car on the freeway. You slam on your brakes and are rear-ended. Your car is fine, so you continue on until you can safely pull over to the shoulder, but the other car is out of commission and pulls over several hundred feet behind you. The other individual jumps out of his car with a machete and charges at your vehicle, screaming that he's going to kill you. You exit your vehicle and take a position up behind your driver's door. You shout commands continuously for the 40 seconds it takes for the other individual to reach you. You shoot the individual as he gets within 21 feet of you. So things that stand out to me is, again, one, the person is several hundred feet behind you. Your vehicle is fine and it runs and you could still drive it. You're in your vehicle when they get out of theirs with a machete. You exit the safety of your running vehicle and you get behind your door and you shout commands for 40 seconds as that person is closing that gap. And once that gap gets down to 21 feet, then you use your firearm to defend yourself. Couple things. You could have stayed in your vehicle. Now, I will say don't stay in your vehicle and just stay there, because can a machete break through a window and then be used against you in order to take your life? Absolutely. So don't just stay in your vehicle. Take and use that vehicle and exit that situation. All right? Exit that situation. Now, you might say, oh, then I'm leaving the scene of an accident. Leave the scene. Get out of there. Create that space. Get on the phone. Call 911. Let them know that you're going to be driving to the sheriff's office or the local police department. What just happened? You just ran an incident. You tried to stay there. You wanted to stay there, but an individual was coming at you with a machete, and explain that you left the scene to avoid using deadly force. All right? That is completely reasonable and understandable in that scenario, in that context. All right? If you can avoid a situation, if you can exit a situation and ensure your safety that way, that is much better than staying and keeping yourself in this situation or injecting yourself in a situation where you have to use deadly force. Avoid using deadly force at all points in time. Again, to kind of summarize and bring it all back together, all right, the general rule is that you only use deadly force in extreme necessity. It was needed. It was required. As a last resort, when all lesser means have failed or cannot be reasonably employed. In a self-defense incident, if you ever use force or even threaten to use force, be sure to call 911. If you can, have somebody else, though, make that phone call, whether it's a witness or somebody standing by, have them make that phone call. But ultimately, if you have to, make sure that call is made. Now remember, when you're on that phone, whether they let you know that or not, that phone call is being recorded. Anything you say or do can and will be used against you in court down the road. You want to keep what you tell them short, sweet, to the point. Tell them what you need, what resources you need. That person on the other line of the phone, they are a dispatcher. They are not law enforcement. They are not anything outside of that. They are a dispatcher. Let them know what resources you need them to dispatch. You do not need to explain to them what happened. You do not need to explain to them what led up to you using force. You do not need to let them know and explain to them why you use force or how you use force. What you need to let them know is that you were a victim of a crime, that you defended yourself, and that you need police and that you need ambulance there now. With that also being said, it's not a bad idea when they get there, make sure that you get checked out by EMS. You know, they might catch things that you don't see or notice. It sounds astonishing, but there are times where people have been stabbed, possibly and or shot, and they didn't even realize it until after the fact, minutes later, or even maybe hours later. Be sure to get checked out by the EMS providers that show up. Now your next phone call is going to be to your attorney. As soon as you get off the phone with 911, make sure you call your attorney so they can get to you and start their legal representation of you as soon as possible, because you should not be making any statements without your attorney present. Now, even with that phone call to your attorney, make sure that you do that with privacy. Make sure nobody else can listen in to what your conversation is with your attorney, because that conversation should be private, and anything that somebody hears from that conversation, if they happen to be standing about 5 feet, 10 feet away and they hear that conversation, they can be called up as a witness against you in that case. Last but not least, make sure that you call your family. Let them know that you're all right. Don't let them find out from some type of Facebook post or a news story on the local news. Make sure they find out from you that, hey, I was in an incident, everything is fine, I'm all right, I'll be home later. I also, very important part too, is that you do not consent to any searches of your home, of your office, of your vehicle, nothing of the sort. Because if law enforcement show up to your home and a family member or friend's there and they answer the door and they consent to a search, that is a legal search. So make sure that they don't give consent, just as you do not give consent to any searches. Now, if law enforcement have a warrant and or they have probable cause, no consent is needed. At that point, there's nothing for you to really do. That's up for your lawyer's job at that point. But again, make sure you do not consent, nor nobody else on your behalf consents to any searches. If law enforcement are asking to search, it's because they don't have that warrant most of the time and or that probable cause. And they need that. So don't consent to any searches that are requested by law enforcement. You're going to still give basic information to law enforcement and stuff, very, very basic but necessary information, such as I was a victim, I was attacked, this is the person that attacked me, I defended myself, right? If there happens to be any evidence that might be overlooked, like, oh, you know, there's some casings over there, there's a neighbor over there that was a witness, they went back inside their home, things like that, because that evidence is going to help prove your innocence. The evidence doesn't lie, but it can be overlooked and maybe even missed, so you do not want that to happen. Make sure that they find and see all evidence and witnesses that might be there, all right? Also, again, and with, you know, the way you started, the way you end also is let them know that you've contacted your attorney and that you do not want to make any further statements without your attorney present. All right. Even with you proclaiming that statement, they may still poke and prod and ask different questions, even though you've made that statement. But you need to be consistent and thorough in saying that you do not consent to any searches, that you do not provide any type of statements without your attorney present. Now, attorneys are not cheap, at least good ones. Good attorneys aren't cheap, and cheap attorneys are not good. You want to make sure that you have a good, competent legal team supporting you and fighting on your behalf. But that's expensive. Right? A good solid lawyer starts out at least at $500 per hour. And I, nor most common people, are going to have the ability to afford that. All right? But you want to make sure that you have a good legal representation supporting you. And a good way to do that and not break the bank is to get a membership with US Law Shield. U.S. Law Shield, you pay a monthly rate. Mine is, I believe it's like $16 or $17 a month. Plans start at about $11 and they can go all the way up to the $20 range. But with that, you pay it every month, and if you never need it, you never need it. And that's the hope, that's the desire. But if you need it, you call them and they will send a lawyer out to you to fight on your behalf, to show how you were civilly and legally in the right, right? With that being said, you don't pay that attorney anything. No talks of payment or monetary financial gains or anything like that. Nothing that's being talked about with that attorney. They deal with U.S. Law Shield. U.S. Law Shield pays them. You all, when you're together, you get to focus on that case because that's the most important thing at that time. You have a lot of things going on in your world and a lot of things on your mind, a lot of stresses, and that's one less stress that you want to have to worry about is how am I going to pay for competent legal representation? And U.S. Law Shield is that answer. Now, this concludes your DC law portion of your training. I've thrown a lot of information at you, and it's a lot to digest. I, nor nobody else, expects you to be a legal expert after this training. And I'm not a legal expert myself, nor was this legal advice. Please be sure to put any and all questions you might have in the comments below. If you remember nothing else from this training, remember this, to shut up and lawyer up. Let an experienced and knowledgeable professional fight on your behalf to show how you are legally right and civilly not liable. Being protected isn't limited to being armed with a gun and having quality firearms training. It includes having competent legal representation on your side. Thank you all again for watching with us. Be sure to hit that thumbs up button as well as subscribe here on our YouTube channel, PTPGun.com Firearms Training, as we post several videos each and every week to make you a safer, more knowledgeable citizen.